Welcome to Mentoring with the Masters. I'm Kelly Overstreet Johnson, and I'm going to be giving you some tips for mediation. I have been asked to talk to you a little bit about what you need to know about mediation as a young lawyer. And so I'm going to be telling you what I have observed over the years. Just by way of background, I am a certified circuit civil mediator. I'm also a litigator, and I've been a litigator for almost 30 years. So I'm going to give you some tips both from a lawyer standpoint and from a mediator standpoint. To start with, and this sounds a little elementary, preparation. Be prepared, know your file, and be ready to talk about it. Don't be looking at your file the day before the mediation. Know it, go through it, determine what you need to pull out. One good way to get prepared for the mediation is to do a mediation statement that you give to the mediator. Most mediators appreciate that. I know I do. But as a lawyer, it also helps you get your case prepared because it forces you to kind of lay out the case, the strengths and weaknesses of the case, and to think that through. Another thing you can do is use that mediation statement when you meet with your client in advance of the mediation. Make sure you do meet with your client in advance of the mediation. The client needs to understand the process. They typically do not. They typically will not have been in a mediation before, and they're a little nervous. They may come in and they say, you know, I'm not going to take a penny less than whatever the number is. Your role needs to be to explain to them what the process is, what's going to happen, make sure they don't have a line in the sand, if you will. Talk to them about what's going to happen once you're in front of the mediator with the other side. Let them know that this is not the time to be overly aggressive. You are not going to be going in there basically to, excuse my language, piss off the other side. That's not what you want to do. You want to go in there and persuade them and facilitate a settlement if possible. The other thing, if the case isn't going to settle, not all cases do, obviously, you're in a fact-gathering mode, so take advantage of that. Depending on where you are in your case, whether it's early or late, it's an easy discovery tool. So take advantage of that. But again, you need to get the client to understand that this is not a fight in this process. This is a settlement discussion, a settlement mode, and we need to have that hat on. I have seen clients get very upset if they think that their lawyer is not advocating strongly enough for them. It's not that you're not a strong advocate, it's just that your role in that process is different. You're very strong, you're going to talk to them about their case, and you're going to advocate for them, but it's just in a different setting. Make sure that your client knows what the expectations are. Explain to them about summary judgment, the cost of going forward to trial, proposals of settlement, anything that may come up during the mediation process. You want to have let them already hear it from you so that when they go in there, they say, oh yeah, I've heard that from my lawyer. Try to get them out of the unrealistic expectations. Let them know, and I tell the parties in mediations when I'm the mediator this as well. In mediation, you don't have home runs. Mediation is compromise. So the plaintiff is going to accept less money than they want to accept, and the defendant's going to pay more money than they want to pay. It's essentially both sides walk out of there somewhat unhappy. If they don't, the case isn't going to settle. So you need to explain that. I also tell both my clients and people in mediations, there is no such thing as a perfect case. And typically, I never hear lawyers guarantee results. You need to let them know the strengths and weaknesses of the case realistically. Also, make sure that they know that while you have told them the strengths and weaknesses of their case, you're going to go in and advocate as if you did have the perfect case. But make sure that they understand what you're doing that for, that it's not because you have the perfect case. One of the things that I think is extremely important that I see done wrong all the time is the lawyer who is presenting on behalf of a party does not take advantage of the opportunity to talk directly to the other party. This is a great opportunity. So rather than addressing your remarks to the mediator, which is what I see a lot of people do, talk directly to the party and let them know what it is that you think about the case, but let them see you in a more of a facilitator type role so that you're not the evil one. Have a conversation with them, and that sometimes will help facilitate settlement. Let your clients know that if they want to, that they will have an opportunity to say something to the other side directly within those confines of the mediation. A lot of times we as lawyers don't like that, and I tend to not want my clients to do that. But sometimes it helps. For example, if there are some hard feelings, an apology, or I'm really sorry that we got to this stage just at the very beginning of the mediation, helps a lot. So, I mean, that's one of those things that you just have to gauge. Don't be afraid to ask the mediator for suggestions. Particularly as a young lawyer, you may not have as much experience, or you won't have as much experience in mediations. Your mediator may well be a lot older and have a lot more years of practice. If the mediation's going along and you're not real sure what to do next, don't be afraid to say to the mediator, do you have a suggestion? What do you think would be a good next move? And they will be happy to help you, because that is what they're doing. They're there to facilitate a resolution of the case. One other thing that I see happen a lot is the lawyers sometimes during the breakout sessions will try to talk for their clients and not let their clients vent. This is an opportunity within the confines of the mediation to let the client talk about their case, let them ramble, whatever you want to call it. Go ahead and let them do that. Eventually, it will kind of calm down. But there is a certain sense in terms of the process that they need to do that in order to make the case resolve. So let them do it. You can help them through that. The mediator can do the same. But it's a good exercise to go through. One other thing I want to mention is make sure that in your preparing for the mediation that you have the appropriate people attending the mediation. If you have a client that is married and they're not going to be able to make a decision, or they don't want to make a decision without their spouse, call the other side and ask if that's okay if the spouse participates in the mediation. And when I say participate, I mean be there. A lot of times, as a lawyer and as a mediator, it's okay with me. You just have to make sure that the spouse understands the ground rules and agrees to be bound by the same rules. But often that will help facilitate the mediation as well, because you don't want to be in a situation where you're there and your client is not willing to make a decision because they can't talk to their spouse. Sometimes it's just support. I've seen cases where literally the spouse has nothing to say, but the mere fact that they're sitting there is helping. In concluding, let me just say that all of these things are pretty common sense things to do in mediation. But if I could say one thing, it's be prepared. All of these things have to do with preparation. In order to get your case settled, you have to know your case. You have to be more prepared than the other side. If there is a case that's on point or an attorney's fee issue that's there, make sure and have it with you at the mediation. If the issue comes up, you want to be able to say, oh, well, here, Mr. or Ms. Mediator, here's the case, and let the mediator use that to your benefit in talking with the other side. But preparation is key, particularly with your client, not only just the other side, but your client, because you need to have your client understand the process. Hope that's been helpful.